Hello dear friends, my name is Milad Haghani, a lawyer practicing out of our Richmond Hill office here in the Greater Toronto area in Ontario. In this video, I will address a few topics about the value of personal injury settlements or judgments, specifically about assessing these values, subjects that I hope will assist you in determining how much your case may be worth. But first, it's important to point out a few of the main principles that apply in making assessments of your losses, in whether it's a out-of-court settlement or a court judgment. The main principle in determining the value of a personal injury case is that the plaintiff or the injured party must be placed in the position he or she would have been, insofar as the money can help, if not for the negligent act of the defendant, no better or worse. As a result, the condition, medical condition, psychological condition of the injured party prior to the accident will become relevant. It's something that will be looked at, which is why we ask our clients about their physical and mental condition prior to the accident, and which is also why we ask them for authorizations, or we ask them to go obtain their records for a period going a few years prior to the incident. The other important principle to keep in mind is that at least in most cases, punishing the negligent party is not a factor in determining the value of your case, no matter how egregious the negligent act may look to most of us. So the egregiousness of the negligent conduct, at least most often, has no bearing in determining the value of personal injury damages award. Of course, there are those very exceptional circumstances where punitive damages may be awarded. Now, another important factor in assessing the monetary value of a case is to actively avoid double recovery. Recall the main principle I pointed out earlier in this video is to place the plaintiff in the position he or she would have been, not better. Therefore, in assessing a loss of income claim, for example, in a car accident case, if the injured party received income replacement benefits from his or her accident benefits provider, in the tort claim, the value of those income replacement benefits received will be deducted from the value of his or her losses in the settlement or judgment. Or if the plaintiff, for example, received long-term disability benefits before the settlement of his or her tort claim, those disability benefits will be deducted from the award of past loss of income claim. Now, the other principle that I wanted to discuss with you today, which is often referred to as the thin skull rule or the thin skull principle, essentially states that if, because of some pre-existing conditions, the accident has a more severe impact on the plaintiff should be compensated according to the subjective impact on him or her, not what an ordinary person or not what an objective person otherwise would have experienced. In law, they say the negligent person must take his or her victim as they find them, even if the plaintiff's injuries are more severe than they would be for a normal person. The thin skull rule, or the thin skull principle, originates from this old court case where someone managed to kill somebody else by hitting that person in the jaw. Now, everyone agreed that the perpetrator didn't really hit the deceased very hard and that such a blow would not normally kill a person. It turned out, however, that the deceased had an unusually thin skull, and a blow that should have only hurt him a little bit ended up killing him. The perpetrator argued in court that he shouldn't be held responsible because he didn't know that the deceased had a thin skull. But the court said that you should not go around hitting people, and if and when you do, you will be held responsible for the damage that you cause. To demonstrate this principle by way of another, perhaps more practical example, if the plaintiff suffered from a degenerative or a congenital condition, or even from injuries from another past accident that made him more vulnerable to new injuries, those vulnerabilities are not taken into consideration when assessing the damages resulting from a new accident, from the subject accident. Those vulnerabilities do not prevent the plaintiff from being compensated to the full extent or receive the full value commensurate with his or her injuries. I come across this a lot in my practice when my clients tell me that they worry about what their records may show, what their pre-accident records may show about their pre-existing conditions or injuries. Now, the opposite side of the thin skull principle says that the defendant, the party that you sue, need not compensate the plaintiff for any debilitating effects of a pre-existing condition which the plaintiff would have experienced anyways, notwithstanding the subject accident. This is often referred to as the crumbling skull rule or the crumbling skull principle in law. And to put it in simple terms, if pre-existing conditions, be it degenerative, congenital, or caused by a prior accident, would have at some point caused the same condition as the plaintiff experienced after the accident, those conditions are not compensable. In other words, if the skull was crumbling to begin with, the negligent party will not be held accountable for the crumbling if the accident prompted such crumbling. In the next video, we'll talk more about the types of personal injury damages that are typically recoverable in a personal injury lawsuit. Until then, thank you very much.